trial practice specializing in commercial litigation, antitrust particularly. And also Mike Hartman, who's an associate here in Philadelphia in our commercial litigation practice group. Dan's going to start us off with talking about some of the finer antitrust issues dealing with internet sales. Go ahead, Dan.
Thanks, Chris. Today I'm going to focus on resale price maintenance agreements. It's been a decade since the Supreme Court's seminal decision in Leegin holding that minimum resale price agreements are not per se illegal. We will look at whether now, 10 years later, a manufacturer can agree with its distributor to a minimum resale price without exposing itself to significant antitrust risk. We'll also look at how e-commerce and online sales by distributors expose a manufacturer to many different competition laws and make it much more difficult for a manufacturer to exercise control over the resale price of its products. But before we get started, we're going to do a short primer on the U.S. competition laws. We have the Sherman Act, which is probably the antitrust law that litigants are most often confronted with. Section 1 of the Sherman Act focuses on joint conduct, agreements that restrain trade. Section 2, on the other hand, focuses on unilateral conduct, monopolization, and attempted monopolization. For today's purposes, I will be focusing on joint conduct covered by Section 1 of the Sherman Act. The Robinson-Patman Act focuses on sales to resellers of like products. It generally prohibits manufacturers from discriminating in prices and/or promotional allowances to resellers of its goods. Mike will talk a little bit more about the Robinson-Patman Act later on in our discussion. The FTC Act, Section 5, that empowers the FTC to bring claims for unfair methods of competition. Only the FTC can enforce the FTC Act, does not provide for a private right of action. And then you have state statutes. Most states have their own antitrust and competition laws. Many are modeled after the Sherman Act itself. Now, some of those states explicitly adopt and follow federal law to interpret their own antitrust statutes. And others differ from federal law in significant ways, and we'll look at some of those differences today. Who can enforce the antitrust laws? Well, we have the government enforcers, Department of Justice, the Federal Trade Commission, and state attorneys general. You also have private plaintiffs that are empowered to bring claims under the Sherman Act, the Robinson-Patman Act, and state competition laws. Next slide here. As I said, today I'm going to focus on Section 1 of the Sherman Act. Now again, Section 1 implicates only joint conduct. There must be an agreement. The agreement doesn't have to be written. It doesn't have to be expressed. Only a common purpose or a common understanding is required. A wink and a nod, we often say, is sufficient. That's good enough to show an agreement. Unilateral conduct, again, though, particularly for our conversation today, it's important to remember, unilateral conduct is not actionable under Section 1. Now, virtually all business agreements contain some type of restrictions. Section 1, however, only prohibits unreasonable agreements that injure competition in the market. And again, private individuals can bring Section 1 Sherman Act claims and, if successful, can recover 3 times their actual damages as well as their attorney's fees. Now, there are generally 2 broad categories of agreements under Section 1. First, there are agreements that are deemed per se illegal. These are agreements that are so clearly anti-competitive on their face that no analysis is necessary to determine that they harm competition. Think horizontal price fixing. 2 manufacturers get in a room, they decide on what they're going to charge for their products. No analysis necessary, that harms competition. The second category of agreements are those judged under the rule of reason. These agreements are not as easy to diagnose as anti-competitive and require an analysis of their actual effects in the relevant market. And that is what the rule of reason is. It analyzes the agreement's effect on competition in the market and asks whether the anti-competitive effects of that agreement outweigh the pro-competitive benefits. A classic example of an agreement subject to scrutiny under Section 1 is a vertical agreement between a manufacturer and its distributor that governs the distribution of the manufacturer's products. That is what we have depicted here in this slide, a series of vertical agreements between a single manufacturer and its distributors. Now, one of the most scrutinized types of vertical agreements between a manufacturer and its resellers are resale price maintenance agreements, those that control the price at which the distributor can sell the manufacturer's product. There are two types of resale price maintenance agreements, those that set a maximum resale price and those that set a minimum price. And we'll see that the court's treatment of resale price agreements has evolved throughout time. Prior to 1997, resale price maintenance agreements, maximum or minimum, were considered per se illegal. That meant that a manufacturer could not enter into any agreement with its distributors that set the price of its own products, or at least the resale price of its own products. So in that legal environment, how could a manufacturer exert control over the pricing of its own products outside of having a wholly owned distribution network? We go back all the way to 1919, the Supreme Court's decision in United States v. Colgate. In that case, Colgate had a policy of refusing to deal with vendors who sold below Colgate's suggested retail price. If a distributor did not abide by the suggested retail price, Colgate simply refused to continue to deal with that distributor. In analyzing the policy, the Supreme Court emphasized that without an agreement, there can be no Section 1 violation. Manufacturers are free to independently choose with whom they do business. From that time on, quote-unquote Colgate policies became the preferred way which a manufacturer could avoid Section 1 liability and at the same time maintain some control over the resale price of its products. Colgate policies, however, are not without their difficulties. Termination is really the only way to enforce the policy, and sometimes that can be difficult. For example, if an important or significant distributor violates the policy, will a manufacturer really want to terminate a significant distributor? Oftentimes what we see happen is a manufacturer negotiates with that distributor and tries to bring it back in compliance of the minimum pricing policy. That creates antitrust risk. A plaintiff is likely to argue that the negotiations and the second chance to comply constitutes an agreement. And then all of a sudden the manufacturer finds itself right where it was trying to avoid, within Section 1's purview. So Colgate policies can be very tricky to implement and enforce, and we'll see an example of that in a few moments. But as I said, over time, the Supreme Court's view of resale price maintenance agreements have evolved. The court no longer considers resale price agreements per se illegal. In 1997, the Supreme Court ruled that maximum resale price agreements should not be treated as per se illegal and instead must be judged under the rule of reason. Why? Because there may be legitimate pro-competitive reasons for the agreement. The courts, therefore, cannot say in every circumstance maximum RPM is anti-competitive and illegal. You need to analyze their actual impact on the market. 10 years later, the Supreme Court reached the same conclusion about minimum resale price maintenance. The court held that minimum resale price agreements may in fact benefit competition and that therefore per se treatment is not only incorrect, but actually may result in the unintended harm of competition. Why is that? Well, in Leegin, the Supreme Court listed several examples. First, resale price agreements, minimum resale price agreements, encourage retailers to promote a manufacturer's products by guaranteeing certain margins. The agreements encourage distributors to provide more services. What services? Well, longer sales hours, improved facilities, a showroom, trained personnel that can educate customers about the product. It also, minimum resale price maintenance can also help curb free riding. That is, it prevents a situation where a dealer who doesn't provide any of the services that I just mentioned nonetheless makes the sale by undercutting dealers that do provide those services and have made financial investments in the manufacturer products. So that was 2007. Now we are a decade removed from the Supreme Court's Leegin decision, and the question still remains: what practically, if anything, has changed? Can a manufacturer safely enter an agreement with its distributors, setting a minimum resale price for its product? Now, under federal law, the answer is yes, assuming that the policy passes the rule of reason analysis. And that's an important reminder as we have this discussion today. Leegin did not hold that minimum resale price agreements are per se legal. Instead, it just said that it wasn't per se illegal. Such agreements still need to pass muster under the rule of reason. But state competition laws is really the issue that I want to discuss today and really complicate this question. There are states that have explicitly rejected the court's decision in Leegin, and others that have remained silent about adopting Leegin over the last 10 years. In fact, during the Supreme Court's consideration of the Leegin case, 33 state attorneys general joined an amicus brief supporting per se illegal treatment of minimum resale price agreements. So a decade later, while I think it's fair to say that the mindset of most antitrust economists and even the antitrust bar has embraced the economics supporting the Supreme Court's decision in Leegin, many states and lawmakers have failed to do the same. But why do we need to be concerned with every state's competition laws? Well, even if a manufacturer only has distributors in Leegin-friendly states, if your distributors sell online, online sales potentially subject manufacturers to the competition laws of every state, anywhere a potential purchaser may sit behind a computer. If your distributors, and this is another important point on the slide, if your distributors sell products internationally, online or otherwise, you also have to consider foreign antitrust laws. For example, EU competition law is generally more strict than U.S. antitrust law, and for the most part considers minimum resale price maintenance to be illegal per se, except under very limited circumstances. So the potential application of international law is another important consideration for manufacturers when considering any policy, unilateral or not, that impacts the resale price of their products. But shifting back to the U.S., what are some of the states that have refused to follow the Supreme Court's lead in Leegin? California. In California, the Attorney General continues to maintain that the state's competition law, the Cartwright Act, provides that resale price agreements are per se illegal. In fact, in 2010 and 2011, the Attorney General obtained consent judgments against 2 companies that restricted resale prices. Maryland. After the decision in Leegin, Maryland state legislator passed a law that made minimum resale price agreements per se illegal. And we will see in a moment that the Maryland Attorney General has brought actions recently enforcing that law. New York, not quite as bad. They do not consider resale price maintenance agreements illegal, but they are unenforceable. North Carolina, although there is no case law addressing this issue specifically, the Assistant Attorney General there has publicly stated as late as 2012 that resale price maintenance agreement remains per se illegal in the state. So given the position of these states and the silence of many others regarding resale price maintenance, if a manufacturer's distributors sell online and throughout the country, resale price maintenance agreements continue to pose significant antitrust risk, even now 10 years removed from the Supreme Court's Leegin decision. And as we discussed a little bit earlier, Colgate policies are not entirely without risk either. A string of recent cases involving the contact lens industry illustrates many of the potential pitfalls that remain when a manufacturer makes an effort to control the resale price of its products, even when it attempts to do so unilaterally. In March 2015, Costco filed suit against Johnson & Johnson Vision Care, challenging Johnson & Johnson's quote-unquote unilateral pricing policy that set a minimum price for its contact lenses. Costco brought claims under the Sherman Act and the state competition laws of California, Maryland, and New York. Now, in support of its claims, Costco alleged that Johnson & Johnson, although it characterized its pricing policy as unilateral, instituted the policy as a result of an agreement with its distributors. Specifically, Costco alleged three things: that Johnson & Johnson implemented the policy first in response to complaints from dealers about price cutters. 2, Johnson & Johnson sought input and support from its distributors before announcing the pricing policy. And 3, revised its pricing policy several times based upon distributor comments. Costco also alleged that Johnson & Johnson coerced Costco into agreeing to the pricing policy through the threat of termination, and in fact issued a revised policy based upon negotiations solely with Costco. Now, as expected, Johnson & Johnson moved to dismiss the complaint on several grounds, including that the pricing policy was unilateral and that Costco failed to allege an agreement. Remember, without an agreement, there can be no Section 1 violation or a violation of the state competition statutes. The court, however, denied the motion to dismiss and found that the allegations that Johnson & Johnson instituted the policy after receiving complaints, sought input, and revised the policy after receiving input from distributors was sufficient at the motion to dismiss stage to allege an agreement. Another kind of unique and interesting point is that the court also found that the complaint sufficiently alleged an agreement between Johnson & Johnson and Costco, the plaintiff, because Johnson & Johnson renegotiated the agreement with Costco and ultimately obtained Costco's agreement to comply with the pricing policy. Now, the parties jointly dismissed the case in May 2016 after Johnson & Johnson withdrew the pricing policy, but the story does not end there, as we'll see. In February 2016, almost a year after Costco initiated litigation, the Maryland Attorney General also filed suit against Johnson & Johnson. The complaint alleged that Johnson & Johnson renegotiated its pricing policy with Costco, and that constituted a resale price maintenance agreement that was per se illegal under Maryland statute. Johnson & Johnson settled the case in March 2017, admitting no wrongdoing, but agreeing, 1, to pay $50,000, and 2, that all its resale price maintenance policies had been withdrawn and would remain discontinued. But it continues. Class action plaintiffs also filed suit against Johnson & Johnson and other contact lens manufacturers, claiming that they engaged in both horizontal and vertical price fixing schemes based upon Johnson & Johnson's pricing policy and policies that are similar that were instituted by other manufacturers. Class plaintiffs allege violations of the Sherman Act and California and Maryland competition law. Those cases are MDL'd in federal court in Florida and are still pending. And there's even more fallout. As a result of these cases, Utah has enacted a law specific to contact lens manufacturers prohibiting all actions by agreement or unilaterally that have the effect of fixing prices of contact lenses. These cases demonstrate very well some of the pitfalls that can go with trying to institute a resale pricing policy, even if you do so unilaterally. So where does that leave us? What is a manufacturer to do? If a manufacturer has distributors in states that provide for per se illegal treatment of resale price agreements, or if its distributors even sell online, the Supreme Court's decision in Leegin has very little practical impact. Resale price maintenance agreements still create significant antitrust risk, and typically are not a good decision for a manufacturer. So what do? What's the practical advice? All the way back again to 1919, Colgate policies still remain the preferred choice to minimize antitrust risks. But remember, a Colgate policy is not a silver bullet. There are still risks, as we saw in the contact lens cases. Colgate policies must be crafted carefully, avoiding involving distributors in the process and taking all necessary precautions to keep the policy unilateral. Also, when faced with a price-cutting distributor, a manufacturer must be willing to terminate. Renegotiations, second chances, they all can be viewed as an agreement and expose the manufacturer to per se liability in certain states and to a Section 1 rule of reason analysis. Now, a manufacturer can also consider announcing a non-binding suggested retail price, although that may not be as effective in curtailing price cutters. Another option is a MAP policy, a minimum advertised price policy, but those also are best implemented unilaterally to avoid running into some of the same issues that impact resale price agreements. So where does that leave us? In sum, if you are considering a policy that affects resale prices, even when doing so unilaterally, make sure that you involve antitrust counsel before developing and instituting the policy. Chris?
Actually, this is Brian Dolan. I did want to jump in and let folks know we're going to have our second, code word for CLE. It came a little later, just to let folks know. You have to write down these 4 words. The first one was litigation. The second one will be risk, and I will come on with 2 more after that. Let me pass the ball over to Mr. Young, and he will be able to drive the slides from here. Should be all yours, Chris.
Thanks, Dan. I'm going to switch gears for the next few minutes away from antitrust liability and talk to you about the contractual liability that you need to be aware of and how you can avoid it when engaging in online internet sales. Dan spoke for a moment about, and he showed you a slide that highlighted the traditional distribution network. And it was traditional because it was a very common way for distributors, manufacturers, sellers of goods and services, and franchisors to distribute their products, get their products to the end user in large geographical areas in a cost-efficient way. Stated another way, it would be cost-prohibitive for a seller in New York to invest in the brick-and-mortar stores that would allow it to sell its good directly to an end user or consumer in, say, California. So the distribution networks were created, and oftentimes the distribution networks allowed for the dealers, distributors, franchisees, licensees in some cases to have exclusive territories. And they typically worked that the exclusive territory was, say, to use the same example, California. So there wasn't too much issues there because in the traditional pre-internet days, a New York seller was happy to give an exclusive territory for California because the California dealer had no competition there. So either the distribution agreement expressly said that there wouldn't be competition in California by either the seller or another distributor, or it was implied in the contract that that would take place, or that would be the reasonable expectation of the parties. The internet and internet sales disrupts that paradigm, as most of you know, because it now allows a seller or manufacturer or franchisor to deal directly with consumers through the internet. There's still a good reason to have the traditional distribution network for some of the reasons that Dan mentioned, which is that it's nice to have someone in California, say, where a consumer can walk into a showroom or ask questions about a product. So there's a good reason to have those traditional networks. But the question that we pose here is, if you decide that you want to engage in online sales, where are the risks and how do you avoid them? Risks that are created through exclusive territories that are given in your distribution agreements, exclusive licenses that may also create the equivalent exclusive territory, and also the reasonable expectations of the franchisees, which can give rise to liability under the, could be a breach of the implied covenant of good faith or fair dealing. So I'm going to talk about three general areas here. One is the distribution agreement itself. I'm also going to talk about state law when the distribution agreement does not address internet sales, and share with you a few cases where the courts have dealt with the issue of internet sales and how the outcomes, some good and some bad. And then lastly, talk about the breach or claims for the breach of the implied covenant of good faith and fair dealing, which often arise in these disputes. So first, with distribution and franchise agreements, if you have the benefit of starting your own network, the best advice is to, in your distribution agreement or dealer agreement or your franchise agreement, if you want to engage in internet sales, but also have distributors, franchisees, and dealers, reserve the right to engage in internet sales explicitly in your agreement. If you have existing distributors, dealers, franchisees, and your distribution or franchise agreement does not address internet sales, amend your franchise agreements or distribution agreements to allow you to do it. That's a little stickier because oftentimes that an amendment or an addendum to a distribution agreement, you need to get the agreement of your counterparty, and they're not always willing to do that, especially if they believe that internet sales will encroach on what they believe is their existing exclusive territories. So that can be tricky, and we will also look at a case or two in which trying to do that actually caused some litigation problems. But as far as a point to take away from this is, if you have the ability, if you want to engage in internet sales and you have the ability to draft that agreement, the agreement is where courts will first look to determine the rights of the parties. And if the agreement says that you can engage in internet sales, they will allow your internet sales. Along with the point that Dan made too, is that you can also not only reserve your right to engage in internet sales, but you can also prohibit your distributors and dealers from engaging in the internet sales themselves within your brand or the goods or services that's the subject of your agreements. One bit of caution, however, if you recall Dan's discussion, an agreement, a vertical agreement between a seller and its distributors in which you agree that someone will not engage in a certain sale or certain distribution channel sales could be considered a competitive restraint that would be analyzed under the rule of reason. So be sure to seek antitrust counsel before you put that prohibition in your agreement. Also, beware of local laws. As Dan mentioned, internet sales are often international in scope. For instance, the EU prohibits prohibiting internet sales. So you need to have local counsel as well. So what if your contract is silent as to internet sales? If that happens, and if the court determines that that it does not address the right to engage in internet sales, or whether internet sales constitutes a sale within an exclusive territory, state law will decide that issue. Specifically, especially if your distribution agreement involves the sale of a good, Article 2 of the Uniform Commercial Code will determine the dispute. So I want to share with you several cases that dealt with this issue and can be very illustrative of you of, one, what the problem is that you may run into and how, in this instance, because the contract was silent, how it was resolved. The case is Pro Golf of Florida versus Pro Golf of America. That was a case that was decided by a federal judge in the United States District Court for the Eastern District of Michigan. It was, as you might imagine, Pro Golf of America, or PGA, had a traditional franchise relationship. It sold its goods through franchisees who had exclusive territories. In this case, the franchisee, who was the plaintiff, had an exclusive territory of the entire state of Florida. And it had a brick-and-mortar store in which it sold golf shirts, golf clubs to consumers in its exclusive territory. It was established before the Internet became prolific. At some point, the franchisor, PGA, decided it wanted to sell directly to consumers through the Internet. What it tried to do was what I mentioned earlier about a remedy to the situation of a silent distribution agreement. It tried to negotiate an addendum to the franchise agreement, even offering a royalty on Internet sales, but the franchisee refused. Well, what happened was not only did the franchisee refuse, when the franchisor proceeded to engage in Internet sales, the franchisee sued, claiming that the Internet sales to a customer in Florida violated the exclusive territory. Because the distribution agreement or the franchise agreement was silent on the issue, the court had to turn to state law, in this case Michigan law, because that was the choice of law provision in the contract, to determine, as the court said, where the sale took place. Because the wording of the exclusive territory was that neither the franchisor nor another distributor would engage in sales in the exclusive territory. And that's typical of a lot of exclusive territory provisions. They have similar language. So the court turned to the UCC under Michigan law to decide that the determinative issue is where the physical sale took place. And it looked to the UCC to find out that the sale took place where the seller tendered title to the buyer. And in this particular case, the sale took place at the seller's processing facility, which was a warehouse in Pennsylvania. There was another facility in West Virginia. So it determined that the sale actually took place under the UCC in those jurisdictions and not Florida, because title passed at the time the seller sold the good and handed it over to, say, essentially a courier. And that's under the sales agreement that existed, the court determined, and what was significant there was that the sale was FOB, meaning that freight on board at the warehouse of the seller. So the takeaway is, if you have a silent agreement, make sure that your sales agreement for your Internet sales establishes that you, the seller, are delivering title to the buyer wherever your processing facility is, and that's one way to avoid potential liability to your franchisees who may think they have an exclusive territory. I want to talk now about the implied covenant of good faith and fair dealing. Oftentimes when distribution agreements are silent, the implied covenant of good faith will, courts will use that as a way of writing in terms that don't exist and a lot of times it's because of the reasonable expectations of the parties. And for those of you familiar with distribution disputes, oftentimes distributors, dealers, and franchisees think or have what they believe with the perception of a reasonable expectation of exclusivity based upon their agreements with you, which isn't always supported by the contract. So I wanted to just show you in the conclusion, discuss with you a couple of cases that dealt with that issue. The one is the 1-800-Flowers case. These are not published decisions. They come out of their arbitration decisions, but they're illustrative of what the disputes can be and how courts have ruled. The 1-800-Flowers case was good for the seller, which in this case was 1-800-Flowers, who had exclusive territories to bricks and mortar flower shops, but also would take telephone sales, as the name suggests, 1-800-Flowers. And it had a fulfillment service in which it would assign sales that it received from phone calls to different flower shops. The flower shops that were also franchisees had agreements that gave them an exclusive territory, but it was not for all sales. It was just for walk-in sales within their exclusive territory. In other words, 1-800-Flowers would not put another franchisee within the exclusive territory. But when the Internet came around and 1-800-Flowers started assigning Internet sales, the franchisee claimed that that violated the exclusive territory. And the court held otherwise. The court found that there was a provision in the agreement that allowed the franchisor to utilize other technology, and found that the Internet was other technology, and also found that the language of the exclusive territory provision did not prevent this fulfillment process that had been going on for a long time. So that's the 1-800-Flowers, which was a win for the franchisor. Got a little ahead of myself here. And the last case I want to talk about is the Drug Emporium case, which is a win for a dealer franchisee, and illustrates some of the problems with trying to amend franchise agreements or distribution agreements, and also with the reasonable expectations of the franchisee. Drug Emporium had franchisees who sold drugs, prescription drugs, pharmacy drugs through all bricks and mortar pharmacies, and they had exclusive territories to sell within their area, in which not only would the franchisor would not compete with them, but also other Drug Emporium franchisees would not be established in the territory. Drug Emporium established what it marketed as an online low-cost drugstore, and then proceeded to sell prescription drugs in that online low-cost drugstore at severely discounted prices, undercutting the franchisees. And the court held for the franchisees primarily because of the marketing that the Drug Emporium made about its online store, essentially claiming it was no different than the bricks and mortar stores that its franchisees had. Not only marketing material, but also, if you're a public company, be careful of SEC filings, which came back to haunt Drug Emporium because of the way it described its online sales. But two things to take away from Drug Emporium case was that the franchisor actually offered compensation for online sales during the test period of its online sales to its franchisees, and also it had had honored the exclusive territories for years, and those were two factors that allowed the arbitration panel to rule in favor of the franchisee, to say that the franchisee had a reasonable expectation that it would have an exclusive territory. So something to consider when you want to engage in online sales when you have existing distributors or franchisees, and how you go about doing it. So before I turn this over to Mike to finish our discussion here, just two takeaways. If you could reserve the right to engage in internet sales in your distribution franchise agreement, do it. Be careful about prohibiting others from doing internet sales because it might violate local laws or even antitrust laws. And be careful if you are silent, if your contracts are silent, be sure to make sure your sales, internet sales, are title is delivered at your processing facility. Mike?
This is, sorry, Brian Dolan again. Before Mike jumps in, I wanted to let folks know another CLE word. We're going to go with legal. That's legal. So the 3 words so far are litigation, risk, and legal. Please write them down, and we'll come back before we finish with the 4th word. Mike, it's all yours.
Thanks, Chris, and thanks, everybody, for joining. I am going to talk in the remaining time we have today about the Robinson-Patman Act. I'm going to try to move fairly quickly. As Dan mentioned earlier, the Robinson-Patman Act, or the RPA, covers price discrimination, both direct and indirect, among competing distributors, competing resellers. The RPA is kind of a black sheep of the competition laws. It's esoteric. We've seen enforcement actions all but disappear. There's even been advocacy for its repeal over the years, but Congress has declined to do so. The FTC continues to give guidance, and we still see private plaintiff suits arise quite frequently. And so there's still a certain amount of risk from the RPA in any distribution agreement, and this may only increase as there's new business models adopted, e-commerce continues to grow, and businesses may see more value in having an online presence than brick-and-mortar stores. So I'm going to move fairly quickly over the history of the RPA. It started as an amendment to the Clayton Act, applicable when buyers are competing for customers. And when I say buyers here, I mean distributors, dealers, franchisees, retail outlets. It's a little confusing. The jurisprudence uses the term buyers, which you might normally associate with the end consumer, but here it actually means the distribution level. And so broadly, the claims come in 2 forms. There's price discrimination, straightforward, under Section 2A, and then there's indirect discrimination through promotional allowances under Section 2D and 2E. So again, Section 2A prohibits price discrimination between buyers of commodities of like grade and quality, where the effect of such discrimination may be substantially to lessen competition. 2 notable elements of these claims. If I can get that to work. Right, how can I advance to the next point coming in?
Is the bill.
Okay, no problem. So some of my slides might not have too much information on them. But they are available via PDF, as I think Brian mentioned earlier. So let me go get caught up. So again, some of the notable elements, and I'll go back a couple slides. Price discrimination claim. First, a difference in price. In completed sales to 2 or more buyers, when the word price is used, that's the net price, so the price factoring in any discounts, rebates, or any other price terms which may speak to the net price that the good is being sold to the distributor. Also, the term completed sales, so that means exactly what it says. The sales actually need to be completed. So Section 2A actually does not apply in a competitive bidding circumstance where maybe a sale was awarded to one distributor over the other. Section 2A has no application there. The sales must be reasonably contemporaneous. That sort of speaks for itself. And the commodity product must be of like grade and quality. Commodity here really just means a tangible product, something you can hold in your hand. So Section 2A does not supply any liability for services. And like grade and quality simply just means that the product is the same. It doesn't have any, there's no difference in attributes between the product sold to 2 different distributors that would affect the product's marketability. Another main element, and the one that's probably litigated most frequently, is the element of competitive injury. And that means an actual harm to competition occasioned by the price discrimination. And this comes in a few different forms. There's a primary line injury, which is at the top level. It's actually at the seller level. And these effectively are predatory pricing claims. And since those can be brought under other competition laws, we've seen those all but vanish from RPA litigation. The second is a secondary line injury, which is what I'm primarily going to be talking about today. That's an injury where there's price discrimination between competing distributors, and business is actually diverted from one distributor to the favored distributor, and that would be the distributor itself bringing the claim. There's also a tertiary line injury that's farther down the distribution chain. Maybe a customer farther down the chain claims that it was disadvantaged by the distributor that it's buying from being discriminated in terms of price. So discrimination regarding promotions. Actually, back up on the slide. So defenses, again, apologies for not appearing on the slide in this presentation. I'm going to focus on two of them. There's a few to be aware of. There's a meeting competition defense, there's a cost justification defense, and there's a changing conditions defense, which allows the seller to respond to market conditions such as seasonability or obsolescence when charging distributors different prices. The two defenses that I think are most important to know about are, first, there's a functional availability defense, and that asks the question of whether the lower price was made available to all of the competing distributors. This is litigated frequently and often comes up in situations where there's a volume discount program or some other discount program being given to certain distributors. And the argument is that even though the volume discount was technically available to all of the competing distributors, it was not realistically available because the smaller buyers, the ones with less purchasing power who also couldn't hit very high volume targets, could never practically be able to achieve those high levels of sales, and thus really the lowest prices were not available to them. But so to make this functional availability defense, you have to be able to show, number one, that you made that promotion, or sorry, the discount program available to competing distributors, and also that they could practically take advantage of it. Lastly, there's a functional discount defense, which allows a discount based on a function or service performed by the buyer. This could be something like training a sales force or providing warehousing services. Importantly here too, number one, the functional discount cannot actually exceed the value of the service. And number two, the FTC has taken the position that you actually have to allow all of your competing buyers to perform that function. Now, in the e-commerce context, I think this presents a particular challenge because there may be some functions that a brick-and-mortar store can provide to the seller that really a distributor only participating in e-commerce or primarily in e-commerce couldn't provide. So a great example is a trained sales force where you have people on the floor, perhaps at a showroom, at a brick-and-mortar retail space. And how does an online distributor really offer that? They could perhaps have a customer service force available online via chat or via the phone, but are those things equal? And that's something we really have not yet seen resolved. Discrimination regarding promotions, this is Section 2D and 2E of the RPA, designed to protect smaller businesses from indirect price discrimination. Section 2D involves promotional payments paid, so the seller gives a distributor $1,000 for newspaper advertising. It doesn't give that $1,000 to a competing distributor. Section 2E is where the seller provides that promotional benefit directly. So it gives, the seller gets one of its distributors maybe end-of-aisle displays. It doesn't give it to the second distributor. Claims under 2D and 2E are often brought in conjunction. There's really no appreciable difference in how they're litigated. Courts consider them as a harmonious whole. So a few things to note: discrimination regarding promotions, like price discrimination, a contemporaneous sales requirement, and probably the biggest thing to know about these claims is that in order to avoid liability, a seller has to make the promotion available on proportionally equal terms. So that means reasonably informing competing buyers of the promotion and having, again, as with price discrimination, having a practical and functional ability to take advantage of the promotion. A perfect example is where you're giving a certain allowance for television advertising. Your big distributors may advertise on television all the time and really be able to make use of those funds. A smaller distributor might never advertise on TV because they can't afford it or does not regularly take advantage of television advertisements. And case law would hold that unless you design the program properly, you actually are disadvantaging one of your distributors, and you could violate Section 2D. So in the promotional context, the FTC has tried to provide some guidelines on how firms can comply. These are called the Fred Meyer's Guides. They provide examples and explanations of how to provide proper notice of programs, how to make them functionally available. They were updated in 2014 to reflect the government's position that traditional distribution outlets and online distribution outlets are in competition with each other. Unfortunately, these updates have been largely critiqued because they did not provide any additional guidance that clarified how to make promotions functionally available in equal terms to both traditional and online retailers. Nevertheless, these guides remain an important source to consult when designing any promotional program where you're concerned about RPA liability, and I've included the link on the bottom of the slide that I would recommend consulting just to see how some of these laws lay out. So recent case law, just briefly to give the legal landscape, I'm going to talk about a few cases. In the limited time I have, these cases are generally brought either as enforcement actions by the FTC, although those have all but vanished. So you're left with private plaintiff actions. And for many reasons, these actions are no longer that attractive to the plaintiff's bar, but yet they remain. And so a few examples, again, if you download the PowerPoint, you'll have these case sites. The first case is Woodman's Food Market v. Clorox. This was before the Western District of Wisconsin on a motion to dismiss in 2015 and before the Seventh Circuit on interlocutory appeal last year. And I bring this case up because it involved what products a seller makes available to its distributors. Particularly the plaintiff in this case was a retail grocery store that bought large pack products from Clorox, the kind of things you would see in like Costco or BJ's, a wholesale club. And Clorox designed a new distribution strategy where it no longer made those products available to retail grocery stores, only to the wholesale buying clubs. So Clorox's argument, essentially, there was 2A, 2D, and 2E section claims. Clorox's argument was really bulk packages are not a promotional allowance. They don't involve an actual promotion that could trigger 2E liability. The district court disagreed. It found that the promotion actually had value, it drove customer preference, and thus denied the motion to dismiss. As I mentioned, the Seventh Circuit granted interlocutory appeal. Notably, the FTC filed an amicus brief in that case, so they may not be bringing their own cases, but they certainly are still trying to shape policy. And they said bulk packaging simply isn't a promotion. It doesn't work the same way that other promotional packaging, like football-shaped packages in advance of the NFL draft, which we're having here in Philadelphia tonight, or Halloween fun-sized candy bars. That's packaging that would qualify for 2E protection, but bulk packaging does not. The court, however, left open the question of whether allowing some distributors to purchase bulk packages of products and some distributors to not purchase those could qualify under Section 2A price discrimination liability, because essentially it could constitute a bulk purchasing discount that you're only making available to some distributors. So that remains unsettled. I think that has some particular application in the e-commerce setting, because there's been a trend for businesses to make certain products available only for online sales. And depending on what products those are and what distributors are also selling through online platforms, you may be making products available to some distributors and not others that could trigger some of the provisions of the RPA. So e-commerce application, unfortunately, like the Fred Meyers guys, there really has not been any guidance from the case law. There's very few cases. Most of them concern the things that Dan and Chris spoke about earlier, where through internet sales, there's either issues of competition within exclusive territories, or there's issues with MSRP or MAP policies that restrict the ability of online retailers, online distributors to discount their prices. So really, no clear guidance from courts on what's going to happen here. There was one decision in the Northern District of Illinois in 2014 called House of Brides versus Alfred Angelo that involved wedding dress distribution, and one particular retailer that all its sales were online and it discounted heavily, and there were MSRP and MAP policies introduced that basically took away that competitive advantage. Their Section 2A RPA claim failed because they really could not allege that they had to buy at higher prices as opposed to being restricted from charging lower prices. But the court specifically left open the question of whether any price differentials between online and brick-and-mortar distributors are justifiably pro-competitive. I think this is the exact question that remains open and which injects so much risk into designing distribution strategies, because this remains completely unsettled. Are there new ways of thinking, new ways of analyzing RPA claims that involve online distribution that we don't have any guidance whatsoever on? And I think that's a question that we're going to see have to be answered as new cases arise that do invoke some aspect of e-commerce distribution. So we're running short on time. I had a few hypos, which is why you see Ned Flanders standing there waving at you, and Duff Beer Can. But for the sake of time, I'm just going to go to some practical application points here. First of all is the question of whether these claims are going to remain viable as we move forward. We've obviously seen the FTC stop bringing enforcement actions, but still interested in formulating policy. And I think the cases in many ways are attractive to plaintiffs, to distributors that feel they've been severely wronged in terms of price. These can be very sensitive negotiation situations, and distributors will look for avenues of liability. One case I didn't get to discuss, but an important ruling from actually early this month out in California, was a ruling that seemed to hold that Section 2A cases can no longer be actually brought as a secondary line claim as a class action due to the difficulty in showing competitive injury on a class-wide basis. Whether that case will go up to the Ninth Circuit or have application in other jurisdictions is unclear, but obviously if it's more difficult to bring these claims as class actions, they may be less viable. The flip side of that is, again, as e-commerce continues to become a larger and larger part of the economy, are there going to be new RPA risks that arise that result in more litigation? And that's a question we don't know yet. So everyone in deciding a distribution strategy should be particularly aware. The second point I would say is we've seen in the case law that there's many defenses to these claims. They're certainly defensible, but often they take a long time to resolve. There was a recent decision denying a motion for retrial based on a car dealership case. Again, the defendants won at trial, but they had to take the case all the way through trial on what seemed to be a very vanilla discounting policy. So there's a certain weighing of the risk and cost versus business objectives. I think the legal department should be have a good dialogue with the commercial department, sales and marketing, to ensure everyone's on the same page. And then just some tips on how to manage risks in distribution strategies in terms of RPA. Something that Chris talked about, I think using contract terms to define competition between distributors, limit the contours of online distribution. A great way to avoid some of this is what Chris said, to reserve online commerce for yourself as the seller, but again, that can raise other competition law risks. Functional availability is the key when creating discount programs. Make sure that they're practically available to your distributors that are in direct competition with each other. For promotions and allowances, again, I would recommend consulting the Fred Meyers guides as a starting point. There's really good examples in there, even if it's hard to apply those in the e-commerce setting. And finally, I would say incentive and promotional programs need to be designed to account for the differences between the value of brick and mortar stores and the value of an online presence. This will require some creative approaches when there are particular business objectives regarding e-commerce or an internet presence that really there's no guidance from either the FTC or the case law. So on that final point, I would just say you should feel free to consult outside counsel when designing these distribution programs or promotional programs, just to make sure you're not running afoul of the RPA or other competition laws. So I think that's all I have. I try to cram a lot in, so apologies of running through it quickly.
Thanks, Mike, and thanks, everybody. We did come to the hour. We're actually a little bit over. Just so folks know, I'm going to put my email address up here. Our last CLE word is going to be pepper. So that's litigation, risk, legal, and pepper. Feel free to email me for a form for CLE. We will also send around the PDF of the slide deck, which will include the full slides for Michael. Sorry about that. And we also have the website of pepperlaw.com updated today with the recording of this webinar. With that, thanks, guys, and we're going to cut it. Appreciate it.